We need to change that too. Okay, we are good to go, Frank.
Okay, I call the meeting for the Sex Offender Risk Review Board to order for June 8th, 2023, 10 a.m. It's available to the public on YouTube. Tracy, could I get a roll call?
Mindy Ackerman,
Present.
Gerardo Moore,
Present.
Mandy Ballinger, Ezel Brown, Jerry Bruce,
Present.
Matthew Connolly. Matthew,
Oh, sorry, I had a mute here. Sorry, I had to put it on mute. I apologize.
okay, Katie Grapper,
Present.
Caitlin Morrell. I can tell you that Sherry contacted me, said she could not attend. Frank Mullis,
Present.
Bert Reeves, Lori Rozier.
Here.
Okay, somebody logged on.
Yes. Sure. Yes. Good morning.
Sheriff Brown.
Yes. Good morning.
Good morning. Okay, so we have 8 people present. That satisfies the quorum, including any cases where we have recusals.
I think somebody else just popped in, I thought. But,
Nope.
okay. All right. Our purpose and mission here at the Risk Review Board is protecting Georgia's children and communities at large by identifying convicted sexual offenders that present the greatest risk of sexual reoffending. It is the board's responsibility to determine the likelihood that a sexual offender will engage in another crime against a victim who is a minor or a dangerous sexual offense. Assessments will be used by SORB to determine the risk level of the offenders. Offenders are classified as level 1, level 2, or sexually dangerous predator. All members have received and had an opportunity to review the minutes from our previous meeting. Are there any questions, comments, or concerns? Do I hear a motion to adopt the minutes?
Second.
All in favor, say aye.
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 Any opposed? The motion carries. Are there any reports for the officers or standing committees? I don't believe there are.
No, we don't have any committees currently.
Okay. Any unfinished business?
I don't believe there is.
All right. Do we have any new business? All right. I know Tracy's got several things from the director's report. So Tracy.
So first, just for the public, just want to make it known that we are now called the Sexual Offender Risk Review Board rather than the Registration Review Board. That better depicts what we do, because we are commonly associated with the registration, which to some degree we are, but ultimately we determine risk that a sex offender will reoffend. And so I'm really excited about our name change. And we're able to keep SORRB. That makes it even better. We are in the process of revamping our letters that go out to the offenders, attorneys, judges to better, well, one, to change our name, but actually more so to change some of the language in the letters. So it's going to take a minute to do that. I'm hoping by the July meeting, those letters will be completed. It is going to cost us obviously more money for our database guy to go in and make all those changes. I'm not sure how much that's going to cost yet. So that is going to be part of that, but we're working on that and hopefully that'll be done for July. I'm not positive, but hopefully. The next thing is it was brought up about 7485, that particular case, and there was concerns about the scoring. So it was a great, and Katie had brought up this case. So I'm really I'm glad that you did, because I think it's a good learning kind of tool and explaining some of the scoring and how that's done on the static 99s are specifically. So in this case, the offender had 3 disciplinary reports for exposure to exhibitionism. So when they have that kind of behavior, so they commit their index offense, they're incarcerated for that sex offense, they then get a DR for exposing. We research the DR to determine if there was a target. So some individuals who are in prison masturbate and are caught masturbating, but it's not with an intended target to see them masturbating. So we don't count that as a sexual offense. But if the DR states that they were targeting a correctional officer, then that is considered a sexual offense based on the coding. When that happens, that DR becomes the index offense. So then we have the prior sex offense charges / convictions on the static 99. So that's why he scored the way that he did on that assessment. We reviewed the scoring is correct as a result of his disciplinary report for exposing. Is there any questions about that? Okay. The next thing is just a little bit of an update on Miriam's Law, especially for the public. On May 4th, Miriam's Law was signed by Governor Kemp. And what that law states is there's several things. One is that if an individual commits a second dangerous sexual offense that is listed within that law, meaning they've committed the offense one time, they were convicted of it, prosecuted of it, and then they go and they do it again, there's now and I'm just giving a very brief overview. It can be pulled. You can go into, you can Google Miriam's Law and pull the actual law. It's HB 188. Then they have a life sentence. That life sentence could be incarceration for life or a split sentence that includes a lifetime of supervision. And then the individual will be on electronic monitor until they are deemed not to be a predator for that case. And that can happen in a variety of ways, but you really have to read the bill to get into the smaller elements of that. But that's the gist of that piece of the law. The next part of that law is while an individual is under community supervision, if they have 2 separate sex offense convictions, then they will be placed on monitor by DCS until SORB levels them. And then there's also the piece that DCS officers, if they believe the person presents an immediate risk to the community, they can place a monitor on them. They don't have to qualify for 2 separate sex offenses. So DCS has provided us with a list of those that they've identified that have the 2 separate sex offense convictions, and we are working through that list. I think that's about it. With the understanding that we have 4 evaluators to get through all the cases, which doesn't change. So hopefully at some point we'll get some more funding and that will change so we can kind of work more quickly through these cases, but those are the cases that we're working through. Any questions about Miriam's Law? Okay. And then really the only other thing I have is the next board meeting is July 13th.
All right, thank you very much, Tracy. We're going to move to the review of cases. Tracy, could you explain the leveling process to the public?
Yeah, so SORB receives a list at the beginning of every month from the Department of Corrections for those individuals being paroled. We get a list from the GBI for new sex offenders moving into the state of Georgia that have to register. We get regular emails from the clerk of courts for new sentencing of sex offenders. And we also get regular emails for court order cases where sex offenders are trying to be removed from the registry. So those are the primary lists of individuals. So we're given a name, my investigators then go and collect all the documentation that's necessary for classification, is then sent to an evaluator. They review all the information, they summarize all the information in a report that then goes to the board. The board receives the report without any identifying information, meaning they do not know the offender's name, they do not know their particular status, meaning they don't know that it's a court order case, for example, and they don't know date of birth, anything, well, date of birth they have, but they don't know anything about the offender, is exactly who that person is, to create as much objectivity as possible. The board then reads the case, and then we come to vote on the case. There's then reevaluations. If an individual is classified as level 2 or sexually dangerous predator, they have the ability to request reevaluation or the ability to request judicial review or both, depending on their situation. And then if they do reevaluation, we go through the process again, but reviewing all the information the offender provides to us. You'll see in our list, there's reevaluation cases, and those are the cases that the offender has requested or their attorney has requested that we review the case again, and they've submitted additional information to us. And then once all that's done, then the letters go to the appropriate people, levels updated in DCS and SORT, which is on the registry. I think that covers it quickly.
All right, thank you. Are there any recusals for the level 1 cases? I have one.
That was the only one, I believe.
Okay. Do any of our board members have any questions, comments, or concerns about the level 1 cases that they reviewed prior to the meeting?
I do. I would like to discuss 29775.
That's number 20 on the list.
What stood out to me in this is he got a straight sentence. So he, upon his release, there was no community supervision, no sex offender counseling or treatment, no monitored behavior in the community. And what was significant to me in terms of his plea is that he pled guilty but mentally ill, which I don't expect to be of significance to the non-attorneys. But the law is that the judge is not permitted to accept a guilty but mentally ill plea until and unless the defendant has submitted to a psychological evaluation and the court is satisfied that he meets the definition of mentally ill under the statute. And so the court has to have him evaluated, has to review the evaluation, and has to hold a hearing in order to determine that he does suffer from under the law, it says he must have a disorder of thought or mood, which significantly impairs his judgment, his behavior, or his capacity to recognize reality, or his ability to cope with the ordinary demands of life. So that's how they define mentally ill under the guilty but mentally ill statute. And so procedurally, there should be some record of him submitting to a psychological evaluation, the court making a finding that he suffers from significant mental illness. Otherwise, it would have just been a guilty plea. But he was sentenced guilty but mentally ill. And to me, that in combination with the fact that it was a violent rape, that he had a violent disciplinary report in prison, and that he had no sex offender counseling is very concerning to me. So I don't know if we can table it and try to get the records concerning the guilty but mentally ill plea, because the court would have had to hold a hearing and make a finding, or sort of where we are at with that. But that one stood out to me as being concerning in the context of a level 1, that there's obviously more information that is not in this report.
So I think it's a great idea to table it. I appreciate that feedback, Kate, because we're not aware of that. So I think if the board approves that, we should table it and we can pull it and obtain that psychological, get more information, because I agree with you.
Okay, so I'm assuming Katie, you're making a motion that we table it.
I would. Thank you.
Is there a second that we table it?
I second.
Okay, that's Gerard. All in favor that we table this case number 29775 till there is more information gathered? All in favor?
Aye.
Aye.
Any opposed? Okay, that will be tabled, Tracy.
That's great.
All right,
Thank you.
are there?
Appreciate that feedback, because that's really important. I appreciate that.
Yes, thank you. Are there any other questions, comments, or concerns about the level 1? Okay, do I hear a motion to adopt the level 1 cases that have been presented to the board?
I motion we adopt the 28.
I second.
Lori second. All right, all in favor, we'll do a roll call. All in favor of us adopting these cases for review?
Okay, Mindy,
Aye.
Gerard,
Aye.
Sheriff Brown.
Aye.
It's,
Yes.
I think it's somebody, so
If everybody's muted until they say aye.
okay, can everybody mute until they say hi, because we're getting feedback?
They just muted themselves.
Sorry, Sheriff. Sheriff, what's your vote?
Aye.
Thank you. Jerry,
Aye.
Matthew,
Aye.
Katie,
Aye.
Frank,
Aye.
and Lori.
Aye.
So those passed with the exception of 29775, which we have tabled.
Okay, we'll move on now to our 24 level 2 cases. Are there any recusals for the level 2 cases?
Matthew has 2 recusals, 13831 and 29767.
Okay. Do any of the board members have any questions, comments, or concerns about the level 2 cases that we reviewed prior to the meeting? All right, if there's not any questions, concerns, or comments, do I hear a motion that we adopt the level 2 cases as presented to the board?
I second.
Okay, so there, I believe I heard a second. Is that correct, Tracy?
Yes, George seconded it.
Okay, can I get a roll call, please?
Yes, Mindy,
Aye.
Gerard,
Aye.
Sheriff Brown,
Aye.
Jerry,
Aye.
Matthew, other than your 2 recusals,
Aye.
Katie,
Aye.
Frank,
Aye.
Lori,
Aye.
they all pass.
All right, thank you very much. We'll move on to our sexually dangerous predator cases, and there were 11 of those. Are there any recusals? I believe I have 1.
I have, I have one or 2, I believe.
Matthew has 4431 and 27512, and Frank has 30024 as recusals.
Yes,
All right, are there any questions by any of the members in regards to the sexually dangerous predator cases, comments, or concerns? All right, do I hear that we adopt the sexually dangerous predator case that's been presented for review? Do I hear a motion?
I motion Matthew.
Second, please.
I second.
All right, Tracy, could I get a roll call on the sexually dangerous predator cases?
Yes, Mindy, any questions or concerns about any of the sexually dangerous predators?
No questions, no concerns. My vote is aye.
Gerard, any questions or concerns about any of the predators?
No questions or concerns, and my vote is aye.
Sheriff Brown, any questions or concerns about any of the predators? Sheriff Brown,
He's muted.
My vote is aye.
Jerry, any questions or concerns about any of the predators?
No, my vote is aye.
Matthew, other than your recusals, any questions or concerns about any of the predators?
No questions or no concerns. My vote is aye.
Katie, any questions or concerns about any of the predators?
No, and my vote is aye.
Frank, other than your recusal, any questions or concerns about any of the predators?
No, my vote is aye.
And Lori, any questions or concerns about any of the predators?
No, my vote is aye.
They pass.
Okay, and we have 9 reevaluation cases, and I recognized one of the letters was from someone in our company, so I'm going to recuse myself from 20216.
Thank you.
All right, I don't believe there's any other recusals. Any members have any questions, comments, concerns about the reeval cases that we've reviewed? All right, do I hear a motion we adopt the reeval cases?
So move.
Do I hear a second?
I second.
All right. We have a first and a second on that. So do I have roll call ready there, Tracy?
Yes, Mindy, any questions or concerns about any of the reevaluation cases?
No questions or concerns. My vote is aye.
Gerard, any questions or concerns about any of the reevaluation cases?
No questions, Tracy, my vote is aye.
Sheriff Brown, any questions or concerns about any of the reevaluation cases?
No questions, no concerns, and my vote is aye.
Jerry, any questions or concerns about any of the reeval cases?
No, my vote is aye.
Matthew, any questions or concerns about any of the reevaluation cases?
No, my vote is aye.
Katie, any questions or concerns about any of the reevaluation cases?
No, aye.
Frank, other than your one recusal, any questions or concerns about any of the reevaluation cases?
No, and my vote is aye.
And Lori, any questions or concerns about any of the reevaluation?
No, my vote is aye.
They pass.
All right. I want to again thank everybody for their time they spent reviewing the cases this month. That is, we classified by vote 72 cases this month. And I want to thank the evaluators and the investigators for their hard work again. Thank you very much. And Tracy, as always, great job.
Thanks, everybody. I appreciate it.
Thanks, guys. Have a good week.
We'll see you in July.
Thank
All
you.
right.
Good week.
I'm assuming we there's a motion we adjourned.
Oh, sorry.
So move.
Do I hear a second?
Second.
All right. Thank you. We'll see you in